Hey everyone, this is Jeff. Welcome to today's webinar on the Living Trust. We're just kind of getting up and running and started, so we've got a lot of attendees, and so we'll give a couple more minutes while everyone is logging in to the webinar. But first, just want to say thanks for attending the webinar, and if any of you were at the Utah RIA event yesterday, it was a great event. I hope you guys learned a lot. I actually did and met a lot of new people, so it was a fantastic event. And I guess some other things coming up, just kind of information and housekeeping. You know about this trust series. Today's the Family Trust, and then next week is the Asset Holding Trust, which is a privacy document to kind of keep your name off title. And many clients use the Asset Holding Trust to do things like wholesaling and their flips in, and there's other purposes that it can be used for. So that's next week. And then in 2 weeks is the Asset Protection Trust, which is a very different kind of trust altogether. It's one of the most secure and asset protective devices we have. It's a pretty complicated document. There's some things you need to know about it and learn. But for those with assets, it is probably the most protective tool you can get. And so that'll be in 2 weeks. And then at the end of October, there is the Medicaid Preservation Trust. This applies to mostly older people, but we have a lot of clients actually that are already registered for it, simply because they just want the information, or they may have family members that they're thinking about where they need to protect Medicaid benefits in certain aspects. So you do have to register for each one of those webinars individually. And all those links are on the website, so you can just go back to our website, the store, the same place you register for this, and register for those at any time. Also, we are making known that if you are a wholesaler or want to engage in wholesaling, I am doing a live class on October 17th from 7 to 9 p.m. down at the Larry Miller Center in Sandy to talk about real estate licensing and wholesaling and how they work together and how to stay in compliance, because the division is really cracking down on wholesalers and assessing very large fines and taking away people's licenses. So it's really important that if you're involved in wholesaling at all, that you attend that one on October 17th. And you can also register that. That's also on our website under the live events. And that one you actually register through our website, because I'm hosting that event while these webinars are hosted by GoToWebinar. So that's that. If I can get somebody to maybe raise their hand I should have done this earlier, if they can see the screen and hear me, make sure that audio is working. On our end, it looks like it's working. Great, Joe, thanks for letting us know. Annie, perfect. Okay, so we are up and running. You can hear me, you can see this PowerPoint screen. So we're gonna go ahead and get started with today's webinar on the Family Living Trust. So I'm going to introduce Brett Bryce, who many of you may have met at this LRIA meeting last week or at the Utah RIA event yesterday. He was at our booth in the late afternoon. So Brett Bryce is an associate here at the office, and he is heading up our estate and trusts division. So he will be creating all the family trusts and asset protection trusts that we do. And I'm going to let him sit in the big boy chair and start the presentation. Oh, one thing I am going to record this. Oh, it's recording now. I wonder if that automatically records. Anyways, I'm just chatting. Normally I have to turn on recording, but it looks like it does say recording, so hopefully we're good on recording. And this will be available on the website after the fact, so if you need to review it, you can always go back to our website on our education page and review this. And what did you need?
Just do between slides.
Let's see how to do it between slides. You click on that and then up and down button.
All right.
Okay.
All right, we're ready to roll. Okay, if any of you have the hands up, go ahead and take that off, and then raise your hand or ask a question if you guys have any questions. I don't think, okay, there we go. So today we are talking about what's called revocable living trust. And this estate planning package also includes a will and also financial and healthcare powers of attorney. Sometimes it's known as a family living trust. So just a little bit about me. So I'm new here at Bragg Legal Law, originally from Knoxville, Tennessee. I got a bachelor's in finance from BYU. Then I went to BYU Law School and been practicing for almost 9 years. I presented on these types of subjects as well as Medicaid planning at BYU Education Week and on BYU Radio. I've also presented on asset protection for the National Business Institute. So basically practice in the areas of estate planning, asset protection, elder law, nursing home planning, which is a part of Medicaid and veterans benefit planning, and also do some civil litigation and some other things that need to be done for clients. So let's see here.
Oops. What does that say? Hold on. Where's the problem? Microsoft Power. Sorry, guys. My computer, my Apple computer that I've never been happy with, is apparently not playing well with Microsoft. It's probably some corporate battle. And Microsoft Word products don't really work all that well on my computer. So let's get this back up.
All right.
There you go.
So question is, I'm sure most of you know the estate tax exemption has gone from what used to be less than $1 million back in the day to 5 plus 5.6 million this year per individual. So a married couple gets double that. So a lot of people think, oh, I don't need to do an estate plan. I don't have a lot of assets. That's not the case. Estate planning is very important, even if you don't have a lot of assets, or if you're building assets, or hope to have assets someday. This isn't in the presentation, but just for families that have minor children, you need to name guardians in your will. So we're going to talk about wills today and why they're not sufficient by themselves, but that is one important reason to have a will. Also, it provides protections to both you and your children. It protects assets for potential creditors, not only now, but in the future. Just as an aside, this includes potential ex-spouses. If you've never heard the phrase, in-laws can become outlaws, that's kind of where that comes from. And this is where it's messing up again. It won't let me.
What are you trying to do?
Just move through the slides.
Even with the arrows?
Yeah. Sorry, we're having a little technical difficulty, but we're figuring it out here. All right, so my first summer of law school, just to illustrate this point, I did an internship writing wills for AIDS patients in Uganda. That little girl is a daughter of one of the patients that was in there. So these people, as you can imagine, had next to nothing, but they wanted to pass on what they had to their children. In Uganda, if parents die, the way the law works there, the father's family can come in and take the home, can take different assets that they have, and basically leave the children on the street or in an orphanage or something like that. So although a lot of people didn't have a lot of assets, like I wrote in here, this lady says, I have 4 dresses, some pots and some pans and a bed. And that's what we were writing her will. It's just, very humbling, but at the same time, if they did have a home or any other type of assets, we could legally protect their children through their wills. And so while U.S. law is different than that, just kind of underscores the point that there are things you can do to help protect your children through proper kind of estate plan and build your legacy and protect those that need help being protected. So just to start from the beginning, we're going to talk about different ways that assets are transferred upon death. The first and the most disadvantageous is an intestate estate. That's when you die without a will or a trust or any kind of estate planning device. It can become extremely litigious and contentious, can also be extremely expensive with taxes and court fees and that sort of thing. And Prince is a recent example of that. He died with a $200 to $300 million estate without a will. And it's taken years to sort out. It's been over 2 years. I think they're still sorting it out. As of April, none of his heirs had received a cent of his estate. It had been over 2 years. The court appointed a special administrator to oversee the estate. In this case, the attorneys have asked the court for over $9 million in fees and expenses so far. So the court and state statutes decide who gets what. And then most of you probably know that if this happens, the wife doesn't get all of her husband's estate. She doesn't even get half. It's usually a share of a third, depending on if you have children or not. Anyways, it's not the way that you want to leave your estate to your spouse and to your kids. And the next, we have a will. And there's a saying, and I'm not sure if I coined this saying or not, but I thought of this last night: where there's a will, there's a probate. You've heard of where there's a will, there's a way. Well, where there's a will, there's a probate. Will guarantees probate, which is also not a good thing. That's what Prince's estate is in right now without a will. But if you have a will, you're guaranteed to go through probate because the court has to prove that the will is valid and has to make sure that your creditors get paid for. So a probate is a lawsuit you file against yourself at the time of your death to the benefit of your creditors. The probate's time consuming, can take at least 9 months to years, and can be expensive. The court has to approve your will and approve of distributions to your heirs. It also importantly allows disgruntled and disinherited heirs an easy forum to contest your wishes. They don't even have to hire an attorney. They can just go in and object to the way your estate's being distributed. They can complicate the execution of an estate. I just had this issue with a client of mine a little while ago. The person who had referred her to me said she doesn't have much of an estate. I think it'd be fine just to do a will. And I found out that she wanted to basically disinherit one of her children. I said that's not a good way to do it because it'll be easy for her to fight against it. And we ended up doing a trust. I'm going to talk a little bit more about her, this client, later in the presentation. And finally, wills are also public documents. So you can find out exactly what Prince had in his estate. Somebody wants to go and find out everything you had in your estate and who you gave it to. If you do a will and you go through probate, they can easily do that. If you set up a trust, they can't do that. Another way assets can be passed outside of probate is by contract or operation of law. One of the ways to do this is you can do a payable upon death beneficiary designation on bank accounts, some other types of assets. But trusts are a good way to accomplish this, passing assets outside of probate. So revocable living trust is an ideal way to leave assets to the objects of your affection, which are usually your children. You can protect those assets from potential creditors, including for your children, from the IRS, from judgment creditors. You can protect your children's disability benefits. If you have a child who is on disability or Medicaid or something like that, and all of a sudden they receive an inheritance, they're in trouble. They get disqualified for those benefits. If you set up a revocable living trust with special needs trust provisions in the trust, in case they are a special needs person at the time of your death, then those assets can be protected and protect those disability benefits, and also protect from any kind of judgment creditors they have, such as future ex-spouses, if they have IRS debt, other things like that. With a revocable living trust, you can still effectively control most of that. The decisions, I have a typo there, sorry about that, made about the trust assets, including investment decisions. You are usually the trustee of your revocable living trust while you're alive and while you have capacity. You can pass assets into or out of the trust, and or revoke the trust at any time. We still have capacity. So while it provides a lot of flexibility, it doesn't provide asset protection for those assets for yourself during your life. We're going to talk more about that in a couple of weeks. Mention it a little bit here at the end of the presentation as well, how you can protect those assets that you're worried about having asset protection for while you're alive. Next, talk about durable financial power of attorney. This is part of the estate planning package. So this, a will and a trust usually come into effect after you die. This helps manage your assets and your finances while you're still alive. If you're disabled, or if you set this up before you become disabled or you can also set it up to become effective earlier. It allows for an individual to step into your financial shoes, a trusted individual, and manage your financial affairs. An alternative to a durable financial power of attorney is, upon disability, you would need to petition a court to appoint a conservator or guardian to have a conservatorship or guardianship to be able to manage your financial affairs, which is expensive and also time consuming. Most durable financial powers of attorney are, this is a problem we see in a lot of older ones, or even some recent ones, are too restrictive on the powers given to a power of attorney because they were afraid of gifting too much in the past to trigger gift tax. And because of the new exemptions, and because Utah and other states don't really have a gift tax anymore, or they're phasing them out. In Utah, there's no more gift tax. The gift tax effectively no longer exists. This comes into play. This is something we'll talk about in a few weeks. It's an issue if somebody has a durable financial power of attorney, and let's say they were a veteran right now, they can set up a trust and place their assets into a trust, and the next day be qualified for veterans benefits to help pay for $2,000 to $3,000 a month for assisted living or other things like that. But the problem is, with some of their financial powers of attorney, their power of attorney can only transfer $15,000 per year, because when their power of attorney was set up, they were worried about gifting over that and triggering a gift tax. Well, that doesn't exist anymore, but if their power of attorney says that and they don't have capacity anymore, and they can't gift more than $15,000 a year, and they have hundreds of thousands of dollars they need to put into a trust, that's a big problem. So just letting you guys know, a lot of durable financial powers of attorney have that issue in them, and it's something you need to fix, fix sooner rather than later before you run into problems like that. With healthcare power of attorney, it's similar to a financial power of attorney. It allows a trusted individual upon your disability or incapacity to make healthcare decisions for you. The Terri Schiavo case in Florida is an example of that, where her family members were fighting over whether they should pull the plug or not. Her wishes weren't really known. She was kind of in a vegetative state, but they said she was blinking her eyes, and some of her family members were hoping she could come out of it. And others were saying no. And I think it ended up going to the governor or Supreme Court or something like that in Florida. It was national news, but it's a textbook case of why you should have a healthcare power of attorney, so that your loved ones and those who you trust know exactly what your wishes are as far as that sort of thing. I think most people would not want to live in a vegetative state like that. So it's also a very important document to fill out as well while you have capacity before you're disabled. And also absolves the need to petition the court to appoint a conservator or a guardian, which can cost, just like with the financial powers of attorney, can cost $3,000 or more, which is more than the cost of this estate planning package, which includes the trust and the will. We'd also, I forgot to mention this, even though we would set up a revocable living trust, you have to put assets into the trust for it to become effective. And sometimes some assets aren't owned or don't get put in when you set up the trust. We'd also would use what's called a pour over will, which would pour will assets into your trust after your death. But you want to properly fund your trust as well as you can before then. Here's the top 10 estate planning mistakes. Another typo. Apologize for that. Gifting assets to children improperly before death. It can cause tax and creditor issues. If you're familiar with a step-up in basis, real estate or other property that's subject to capital gains, upon your death, your heirs get a step-up in basis. If it's a spouse, they get a half step-up in basis here in the state of Utah. If it's your children, you and your spouse have passed away, they get a full step up in basis. If you gift assets like that to your children before you die, they don't get that step up in basis, which can be a very, very valuable thing to prevent any capital gains tax issues. Number two, relying solely on a will for estate planning. We've kind of talked about that a little bit. Assets titled jointly is also a big mistake, can be a big mistake, depending on who they're titled with, what kind of creditor issues they might have. If the IRS can levy and lien against bank accounts that are titled jointly, if your joint owner has issues with them, also judgment creditors, things like that can be a big problem. Owning life insurance in your name, insurance payable to your spouse. You prefer to have it payable to a trust to provide some of that asset protection. Family chain for beneficiaries left unprotected. It's easy to do if you don't set up your estate the right way. Little or no management provisions made for beneficiaries. No provisions made for disability prior to death. No or improper beneficiary designations of retirement plans. And then not working with an attorney who understands the need for insurance in an estate plan. Time is of the essence with this type of stuff. If we used to say, if you can predict the day of your death, come 2 weeks before you die and we can take care of everything. That usually doesn't happen for most people. This client that I was talking about earlier that wanted to effectively disinherit one of her children, she had cancer and she was back in the hospital. She had some issues with her cancer, and we had kind of gone back and forth on making sure her estate plan was set up the way she wanted it to be. And she was in the hospital, and I called her and she said, let's just wait until I get out of the hospital so we can execute these documents. And I just had a feeling like that was not a good idea. So I went to the hospital that day and had her execute them, had the nurses serve as witnesses, and she actually died 3 days later while she's still in the hospital. So I'm glad that we were able to do that for her and for her wishes and her beneficiaries. So other types of planning that we will talk about more in the coming weeks, as Jeff mentioned, the Domestic Asset Protection Trust. Also, I like to call it Gift from God Trust because Utah is only one of 13 states who can do this type of trust. Our legislature passed law to try to keep investment assets here in Utah. They didn't want people to keep going to Nevada or other states to try to protect their assets, which could become more expensive for people using an out-of-state trustee with this type of trust. We won't get into that today, but we will talk about that, and I believe in a couple of weeks. Number two, a community property trust can also, this can provide a double step up in basis at the death of the first partner, as we talked about just a few slides ago. If a husband or a wife dies, their spouse gets a half step up in basis. If you put those assets into a community property trust, it can get a double step up in basis upon the death of the first spouse, which can be a very powerful planning tool for people if they don't plan on keeping a large homestead if their spouse dies or something like that, and they'd like to sell it. Use those assets to fund a downsizing and trips to see their grandchildren, things like that. It can save a lot of money in capital gains taxes. I don't believe we have that scheduled as a seminar yet. We might schedule a seminar for that, or we might talk about it as one of these other seminars. What we're also going to talk about is Medicaid and veterans benefit planning, where you can plan a trust. With Medicaid, you need to fund a trust 5 years before you anticipate needing to use the Medicaid nursing home benefit in order to shelter assets from long-term care costs, which can be very expensive, growing exponentially every year, can totally deplete and just devastate somebody's estate if they need nursing home type of care for any period of time. Veterans benefits also work to help. They can help with nursing home if you can't qualify for Medicaid. They also can help with assisted living and home health as well. Special needs trusts kind of fit into some of this other stuff. Sometimes they're standalone if somebody has special needs, or if a child has special needs, you need to put some money aside for them. And also the use of LLCs and asset protection is another way to plan. I know Jeff does presentations on that. I've done presentations on that as well. So this is kind of the nuts and bolts of this type of planning. Does anybody have any questions? If you do, I think you can raise your hand or type your questions down below, and if I know the answer, I'll be happy to answer for you. If not, we can get an answer for you. So I don't think I see anybody raising their hands yet or typing any questions. So if that's it, feel free to call the office with any questions that you might have. The number here is 801-560-2180, or email me, brett@bregliolaw.com. You can also contact me through Jeff. He's your point man. But I believe right now if you already have a trust estate plan set up, we can review that for you for free, see if there's any changes we would suggest. If you haven't set up one of these yet, come in and contact us as soon as you can to start this type of planning, because this is the type of thing, if it's not on the forefront of your mind, it's easy to procrastinate on. And as you can see with Prince and other examples, procrastinating with this type of thing can cause some issues that you would rather avoid if you can. So thanks so much for joining us, and we will talk to you soon. Thank you.